To Lindsay, Ontario now, where we're getting new information on a controversial break and enter. It ended with the intruder being airlifted to hospital and the homeowner charged with aggravated assault. And people questioning what constitutes self-defense in Canada. Angie Seth is watching this story for us this evening. And Angie, court documents were released today, and they're telling us a little bit more about what happened last week and the weapons involved.
Yeah, indeed, Ian. A story, of course, that made headlines. This all happening on August the 18th when an intruder broke into an individual's home in Lindsay, Ontario. So that homeowner is Jeremy McDonald, the intruder, Michael Kyle Breen. According to court documents, at the time of the break-in, and this is what we're learning today, that Breen was wielding a crossbow. That was one of the weapons. He was also out on probation at the time of the incident. So walking you through now in terms of what happened here, there are 4 apartment units that are on top of a few businesses here in a commercial area. And it is alleged that Breen broke into McDonald's apartment through his young daughter's window. And fortunately, Ian, his daughter was not in that room at the time. She was not there. However, at the time then, Breen and McDonald do get into an altercation, a knife allegedly involved in all of this, one of the other weapons here, resulting in Breen badly getting injured. And as you mentioned there, he had to be airlifted to a hospital in Toronto. Both men have been charged, including the homeowner. And that charge on the homeowner sparked a countrywide debate over what constitutes legal self-defense. The Premier of Ontario as well, Doug Ford, weighing in on all of this, saying if someone were breaking into your home, quote, you're going to fight for your own life if you're facing that level of threat. Conservative leader Pierre Poilievre also posting on X last week saying, quote, if someone breaks in, you deserve the right to defend your loved ones and your property. Full stop. So that debate sort of going on back and forth across the country. So when we look at what the law says in Canada in terms of excessive force, this is Section 26 of the Criminal Code. It holds that anyone that's authorized by law to use force is criminally responsible for any excess. And such acts can also be a violation of the Charter of Rights and Freedoms. Now, the question being is how are we determining or defining what excessive force is and the necessity and proportionality of that actual force? Well, that's actually sort of the core principle behind when we look at that necessity. And they sort of say, okay, well, we need to sort of look at the fact that how necessary was this in proportion to the situation that the individuals were in. So that brings in the context to it all. And that's assessing whether force was excessive depending on the surrounding facts and circumstances for that particular interaction. And as I mentioned, the homeowner, Jeremy McDonald, he was arrested. He was charged. He's going to be in court next month, Ian, and his actions will be carefully looked at under the criminal code.
So take us through the charges that each of these parties is facing right now.
Yeah, indeed. And we want to start with Breen first. That is the intruder charged with 4 counts, including break and enter and carrying a weapon, that being the crossbow we mentioned there, to commit an offense. Also, in addition here, failing to comply with an 18-month probation order, which began back in June of 2024. And there's also outstanding charges against Breen for the illegal use of a credit card. At the time, a court order warrant was issued. This was on June 19th for his arrest after he did not show up in court. We understand that he did attend court today. This is according to public records. Over to McDonald's now, the homeowner charged with aggravated assault and assault with the weapon. That's the knife that we've talked about here. He will be in court on September 25th. So we'll continue to follow any further developments.
All right, Angie, thank you very much.
You're welcome.
Balfour Durr is a criminal defense lawyer, also former Crown prosecutor. He joins us from Calgary. Now, Balfour, you were on this show last week and you said there wasn't enough information at that point to make a judgment about whether the resident can reasonably claim self-defense. We have a bit more information today. Does that change anything for you?
Well, it gives us a better insight and adds some to it, but we still need to know exactly what the homeowner did. Because as I said, it's just because there's an intruder doesn't mean it's open season. So that, but if the homeowner in this case has a knife and the intruder had a crossbow, just looking at the 2 weapons themselves, I don't see a problem for the homeowner in that. The crossbow would certainly be considered a weapon that could cause death or serious injury. And so responding with a knife would seem to be, just looking at the weapons, a proportionate response. But we need to know more to determine the response was reasonable overall. I mean, and what could happen, Ian, is that the offender may have been disarmed very quickly or knocked to the ground and didn't have the weapon in his hand or anywhere close to him. At that point in time, if there were, stabbing taking place, that was when the offender, the intruder, was down and out, that could be the excessive force that renders self-defense ineligible.
Yeah. And I would say, as a journalist who's covered a lot of court cases, here's my view. This is a good example of why we need to have more information at this point. I know that prosecutors, and you're a former prosecutor, are loath to get a lot of information out there because there's concern that it might affect an eventual trial. But here's this big public debate going on a very important issue. People have very strong feelings, and we don't have the basic facts in order to assess whether these charges should have been laid. What do you make of how highly charged and political this debate has been about whether the homeowner should have been charged at all?
Well, I think it's a live topic here in the country, across the country, and most people had the reaction of, the Mr. Polyev, Mr. Ford, that if someone's coming in my house, I can do what I want. It's not that black and white. It's always shades of gray when we're talking about criminal law. In theory, a person has the right to defend themselves against an intruder or defend their family. There's no question about that. And if that's what these gentlemen are saying, they're right. But there are limits on it. And so it would be very helpful if the police had just said, look, the reason why the homeowner is being charged here is that we believe there was excessive force and that this or that the intruder was basically captured when the force was applied, or anything like that. On the other hand, I do get why the police don't want to prejudice a potential trial down the road by putting things out into the public that could theoretically affect some jury down the road.
Yeah, but listen, I've never seen a case, and I've been a reporter for a long time, where information that's come out early has ended up prejudicing the case. I don't know. Have you seen one where it's actually had a material impact, like that something that a witness said or an accused said, or even the police have said, that something that was said ended up materially impairing a trial later on?
Well, I personally, in the 45 years I've practiced criminal law from both sides, haven't experienced that personally. But in the research that I've done, I have read cases where there is a prejudice created by what was out in the media, and we try to combat that with a change of venue, for instance, the trial in a different place. But I do appreciate what you're saying, and that is that what the police or what comes out in the media today isn't too likely to affect something 9 months down the road. Although it's different times now, it's not just a report in a newspaper, it's something that's captured on a news feed that can be replayed over and over for months, years to come.
Yeah, very reasonable point of view you have. You and I should have a little debate about this a little bit later on. I think it's but in the meantime, it is very difficult to assess whether these charges ought to have been laid. The self-defense, whether self-defense should apply here without the facts. That part, I think it's just very difficult for us to assess. Balfour, thank you very much for chatting about this again. And when we get more information, we'll come back to you again. Thank you so much.
Thank you. Good night.
Balfour Durer is a criminal defense lawyer and a former Crown prosecutor.